Hello there, a blessed day to all of you guys. So we are the group 1 from BSc 2-6. So in this particular lesson, we are all talking about the Title 8 or the crimes against person, which covers the article 246 up to 266. So chapter 1, destruction of life. Section 1, parricide, murder, and homicide. So in this article, I will be talking about the article 246, which is parricide. So any person who shall kill his father, mother, or child, whether legitimate or illegitimate, or any of his ascendant or descendant of his spouse, shall be guilty of parricide and shall be punished by the penalty of reclusion perpetua to death. So who is liable in this article? So the answer is any person who shall kill his father, mother, or child, whether legitimate or illegitimate, or any of his ascendant or descendant, or his spouse. So the penalty here is the reclusion perpetua or 20 years and 1 day to 40 years of imprisonment. So in this article, so we have three elements that should always remember by the heart. So first, that the person is killed. Second, that the deceased is killed by the accused. And third, that the deceased is the father, mother, or child, whether legitimate or illegitimate, or a legitimate other ascendant or other descendant, or the legitimate spouse of the accused. So always keep in mind that legitimacy only applies either the father, mother, or child. So if we say ascendant or descendant, it should be legitimate relationship, and also the spouse should be legitimate.
For example, you have a mistress and she killed you while you were asleep. This case won't fall under this article since it is an illegitimate relationship.
So to further discuss this, I will give an example. So Ephraim Constantino is a Benedict Padua's illegitimate son. So out of years of neglect and resentment, Ephraim killed Benedict. So in this case, the crime committed is parricide. Although the crime is based on legitimate relationship, the exception, as I said while ago, even though Ephraim is an legitimate son of Benedict, the killing of his father, or should we say his illegitimate father, is still under the parricide. That's why he should be liable for this article and should be punished by reclusion perpetua. So next, Article 247. Death or physical injuries inflicted under exceptional circumstances. So any legally married person who having surprised his spouse in the act of committing sexual intercourse with another person shall kill any of them or both of them in the act of immediately thereafter, or shall inflict upon them by any serious physical injuries shall suffer the penalty of disgero. So who is liable in this article? The answer is any legally married person who having surprised his spouse in the act of committing sexual intercourse with another person. So we have to remember that our girlfriends or boyfriend is not included here, for it is clearly said that any legally married person is only included in this article. So the penalty here is disgero. So what are the elements of this article? So first, that a legally married person or a parent surprise his spouse or his daughter, the latter under 18 years old of age, and living with him in the act of committing sexual intercourse with another person. Second, that he or she kills or any both of them, or inflicts upon any or both of them any serious physical injury in the act of immediately thereafter. Third, that he has not prompted or facilitated that prostitution of his wife or daughter, or that he or she has not consented to infidelity of others. So there are two stages enumerated under this article. So first, when the offender surprised the other spouse with paramour or mistress, the attack must take place while the sexual intercourse is going on, meaning you should witness them while doing sexual intercourse. If the surprise was before or after intercourse, no matter how immediate it may be, Article 247 does not apply. So the offender in this situation only gets the benefit of a mitigating circumstances, that is sufficient provocation immediately preceding the act. Second, when the offender kills or inflicts serious physical injuries upon the other spouse or a paramour while the act of intercourse or immediately thereafter, that is after surprising. So you must differentiate the stages, since the first stage will not tolerate any circumstance other than sexual intercourse. Because the parties are just the preliminary, the article cannot be invoking if the unexpected happened before any actual sexual intercourse could be done. So however, even the act implies that they did have a sexual intercourse, the article will still does not apply if the surprise occurred after the sexual intercourse or they are already dressed up, meaning you should catch them in the act of sexual intercourse. So to make it more clear, let's give an example. So one day Angela came home from the market and heard a conversation in the master bedroom. So after this, she immediately opened the door and discovered Brian, her husband, having sexual intercourse with Trisha. So with Trisha, which is the mistress of Brian. So Angela stabbed both of them with a knife and eventually died. So in this case, Angela will be liable under Article 247. So to clear things up, this article is not a felony according to the Supreme Court. For Article 247 is both a privilege and a defense. So the accused is immune from the criminal culpability if Article 247 is asserted. So always remember, or we have to remember always, that the penalty of dischero is not really intended as a penalty but to remove the killer's spouse from the vicinity and to protect him or her from the acts of reprisal, principally by relatives of the deceased spouse. So this is all for today. So I am Charles Joseph Siringin from BSC 2-6 Group 1. So thank you for listening.
Article 248 is about murder. Murder is punishable by reclusion perpetua or for a period of 20 years and 1 day to 40 years of imprisonment. And the offender of this crime can be any person. Take note of that. There are 4 elements present for a crime of murder, and this includes: number 1, that a person was killed; 2, that the accused eventually killed him; 3, that the killing was attended by any of the qualifying circumstances mentioned in Article 248; and lastly, that the killing is not parricide nor infanticide. And 3 are the attendant circumstances that are also found in Article 14, the aggravating circumstances, except for the last one that I will going to mention. And these are: number 1, treachery, or taking advantage of superior strength with the aid of armed men or employing means to weaken the defense or of means to ensure a person and to afford mutiny. Number 2, in consideration of price, reward, or promise. Number 3, by means of inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment, or assault upon a railroad, fall of an airship, by means of motor vehicles, or with the use of any other means involving great waste and ruin. Number 4, on occasion of any of the following calamities: earthquake, eruption, flash floods, destructive cyclone, epidemic, or any other public calamities. Number 5, with evident premeditation. And lastly, with cruelty, by deliberately and inhumanly augmenting the suffering of the victim, or outraging or scoffing at his person or corpse under Republic Act 7659. If one of these attendant circumstances have been done while killing someone, it will have qualified the crime from homicide to murder. And to further understand this, let me give you an example. What if Berto and Baste hack each other over online sabong and Berto eventually died as a result of it? What could be the offense that was committed by Baste? And the answer is, it's a case of homicide, because according to the example, there is no scenario that qualifies the crime as a murder. But in the same problem, what if Baste, who is unsatisfied with slaying Berto, mutilated his body and placed his severed head on his gate? What offense had been committed by Baste at this point? Baste committed the crime of murder at this point, because I have said earlier, if the perpetrator attempted to dismember different sections of the victim's body in order to mock, condemn, or humiliate the victim's corpse, this would be considered as murder, because this scenario is recognized under Article 248, even if it was inflicted or performed after the victim was already dead. And for the next article, we're going to talk about Article 249, Homicide. Homicide is punishable by reclusion temporal or having a duration of 12 years and 1 day to 20 years of imprisonment. And the offender can be also any person. The elements of homicides are 1. That a person was killed. 2. That the accused eventually killed him without any justifying circumstances. 3. That the accused had the intention to kill, which is presumed. And lastly, that the killing was not attended by any of the qualifying circumstances of murder, or by that parricide or infanticide. In short term, homicide is the unlawful killing of a person not constituting to murder, parricide, or infanticide. Let me give you again an example. What if Mario, a barangay tanod, suspected one as another person who are suspect for robbing a bank and kills the latter? Why was the crime committed homicide and not murder? The answer is, the crime committed by Mario will fall into homicide, because since there is no attendant circumstances done while killing one, it's just that Mario assumed that one was the person who robbed the said bank. That's why he killed him.
Hello everyone, I'm Giancarlo Esamblon from BSC 2-6 and I will discuss the Article 250 of Revised Penal Code of the Philippines. Article 250. Penalty for frustrated murder or homicide. The courts, in view of the facts of the case, may impose upon the person guilty of the frustrated crime of parricide, murder, or homicide, defined and penalized in the preceding articles, a penalty lower by 1 degree than that which should be imposed under the provision of the Article 50. The courts, considering the facts of the case, may likewise reduce by 1 degree the penalty which under Article 51 should be imposed for an attempt to commit any of such crimes. The principals, accomplices, or accessories who committed frustrated or attempted cases of offenses are discussed in Article 51 of the Revised Penal Code, and their sentences are reduced in this situation. First is
Good day everyone, I'm Giles B. Salazar of BSC 2-6. I'm going to discuss about Article 251 and 252 of Revised Penal Code. Let's begin the discussion about Article 251, which is the death caused in a tumultuous affray. The person who took part in this crime shall be punished by prison mayor or the penalty of prison correctional in its medium and maximum period. The elements for this article are the following. First, there are several persons. These several persons must consist of at least 4 persons, and this number came from Article 153 in the 3rd paragraph, which state that the disturbance or interruption shall be deemed to be tumultuous if caused by more than 3 persons who are armed or provided with means of violence. Second, they do not compose, group, organize for the common purposes of assaulting and attacking each other reciprocally. It means when there are 2 identified groups of men who assaulted each other, there is no tumultuous affray. Third, these several persons quarrel and assaulted one another in a confused and tumultuous manner. So, let's define tumultuous affray. Tumultuous affray is a commotion in a confused manner to an extent that it would not be possible to identify who the killer is if the result or inflicted a serious physical injury, but the person or persons whose used violence are known. It exists when at least 4 persons took part. Fourth, someone was killed in the course of a fray. This someone is the victim, or it could be the participant in the fight or mere passerby. Fifth, it cannot be ascertained who actually killed the deceased. Sixth, the person or person who inflicted the serious physical injuries or whose used violence can be identified. So in element 5 and 6, it mainly talks about who are the liable. In this is the following: the person or persons who inflicted the physical injuries or serious physical injuries. If it is unknown or who inflicted the serious physical injuries on the deceased, all persons who use violence upon the person of the victim are liable. The crimes committed might be disturbance of public order, or if the participants are armed, it could be tumultuous disturbance, or if property was destroyed, it could be in malicious mischief. For example, Jeffrey turned 50, so he decided to invite his high school friend in his house for a celebration party. But while the party is going on, a commotion took place in his house involving his friends. This resulted to his serious happening, which his friend named Ren was killed on the spot. Let's dive next into Article 252, or known as the physical injuries caused in tumultuous affray. And these are the elements. First, there is a tumultuous affray. Second, a participant or some participants thereof suffer serious physical injuries or physical injuries of a less serious nature only. Third, the person responsible thereof cannot be identified. And last, all those who appear to have used violence upon the person of a offended party are known. All those who appear to have used violence shall suffer the penalty from the next lower in degree that provided for the serious physical injury inflicted. For less serious physical injuries, the penalty is arresto mayor from 5 to 15 days. The physical injury should be serious or less serious. There is no crime of physical injury resulting from a tumultuous affray if the physical injuries is only slight, because a slight physical injury is considered as inherent in a tumultuous affray. For example, in a secluded alley, Paolo and his friend were laughing until some guy approached them for being loud in their territory. This resulted a fight, and Derek, a friend of Paolo, was lying helpless with serious bruises. Paolo started to contact the police for help, and the guy who started the fight fled the scene. And that's all. Thank you.
Let's go now to our next topic, Article 253, giving assistance to suicide. The penalty on this article is prisión mayor or arresto mayor. The offender can be any person. The provision says that any person who shall assist another to commit suicide shall suffer the penalty of prisión mayor. If such person leads his assistance to another to the extent of doing the killing himself, he shall suffer the penalty of reclusion temporal. What are the acts punished on this article? The acts punished on this article are: number 1, by assisting another to commit suicide, whether the suicide is consummated or not. Number 2, by lending his assistance to another to commit suicide to the extent of doing the killing himself. Giving aid to suicide involves assisting someone in killing themselves through the use of poison, rope, guns, or any other positive and direct methods to urge or encourage them to commit suicide. Take note that if the person does the killing himself, the penalty is similar to that of homicide, which is reclusion temporal. There can be no qualifying circumstances because the determination to die must come from the victim. This doesn't contemplate euthanasia or mercy killing, where the crime is homicide. To help you to understand what this article is all about, Let me give you an example. Baste was planning to kill himself when Alden arrived. Alden helped Baste, but Baste survived. Baste did not pass away. Is it possible that they are both legally liable? Answer: because suicide or attempting to commit suicide is not a felony in the Philippines. Only Alden is criminally culpable. Only the individual who assists in the suicide attempt is criminally accountable, not the person who tried suicide. We go now to the next article, Article 254, or discharge of firearms. The offender on this article is any person. The provision says that any person who shall shoot at another with any firearm shall suffer the penalty of prison correctional in its minimum and medium periods, unless the facts of the case are such that the act can be held to constitute frustrated or attempted parricide, murder, homicide, or any other crime for which a higher penalty is prescribed by any of the articles of this code. So what are the elements of this crime? First, that the offender discharge a firearm against or at another person. And second, that the offender has no intention to kill that person. To further understand what this article is all about, let me give you an example. Police Officer Torres were in a class and demonstrating the proper discharge of the gun and the function of it. Unintentionally, the gun has a bullet and was fired against Peter, his student, and was a shot in the leg. As mentioned in the element, the offender doesn't have intent to kill. And clearly in the example, this state that the police officer Torres is merely demonstrating and it was an accident.
Now, it's time to talk about the right to live of the innocent child. We're going to tackle an article which belongs to Section 2 of Title 8 and belongs to destruction of lives. So let's begin. This article is Article 255, or infanticide. This punishable crime has a punishment for the penalty provided for the parricide in Article 246 and for murder in Article 248. If the crime is penalized in this article be committed by the mother of the child for the purpose of concealing her dishonor, she shall suffer the penalty of prison correctional in its medium and maximum periods. And if said the crime be committed for the same purpose by the maternal grandparents or either of them, the penalty shall be prison major. The liable for this crime is any person who commit or kill the child less than the 3 days of age. For that, this article have an elements for us to know it better, and these are: number 1, that the child was killed; number 2, that the deceased child was less than 3 days or 72 hours of age; number 3, that the accused killed the said child. Father or mother or legitimate other ascendant who kills child less than 3 days old to suffer penalty for parricide. Other person who kills a child less than 3 days old to suffer the penalty for murder. Only the mother and the maternal grandparents of the child are entitled to the mitigating circumstance of concealing the dishonor. We're now done to the elements. Let's give now an example for this. Maria gave birth to a child. A child is only 1 day old baby girl. She is angry because her child is not beautiful. She got very annoyed whenever her baby is crying. So she get a pillow and cover her child's mouth. She pushed it very strong and she wanted to kill her baby. And she success. She killed her baby. Okay, this example only shows that the mother killing her child, which is a 1 day old child, and she is now facing the crime of infanticide or the Article 255.
So let's now move on to the comparison of Article 256, which is intentional abortion, and Article 257, which is unintentional abortion. So these two articles are both belongs to Section 2 of Title 8, which is talks about the destruction of lives. With regards to the punishment of the said articles, in Article 256, there are 3 different types of punishment, and these are: number 1, the penalty of reclusion temporal if he shall use any violence upon the person of the pregnant woman. Number 2,
the penalty of prison major if, without using violence, he shall act without the consent of the woman. And lastly, number 3, the penalty of prison correctional in its medium and maximum periods if the woman shall have consented. While Article 257, which is an intentional abortion, is prison correctional. In terms of liable person, the only difference is if it is intentional abortion or unintentional abortion by any person. So next, let's talk about the elements of different types of said articles. So let's give first for Article 256. Here are the elements. Number 1, that there is a pregnant woman. Number 2, that violence is exerted, or drugs or beverages administered, or that the accused otherwise acts upon such pregnant woman. Number 3, that as a result of the use of violence or drugs or beverages upon her or any other act of the accused, the fetus dies, either in the womb or after having been expelled therefrom. And lastly, number 4, that the abortion is intended. We're done now in Article 256. Now let's go to the Article 257. And here are the elements. Number 1, that there is a pregnant woman. Number 2, that violence is used upon such pregnant woman without intending an abortion. Number 3, that the violence is intentionally exerted. And lastly, number 4, that as a result of the violence, the fetus dies, either in the womb or after having been expelled therefrom. After discussing all the elements of 2 articles, let's give now an example of it for us for better understanding. Article 256, Intentional Abortion. Maria have a child in his womb. Her boyfriend shocked because he didn't want it, because he's not ready for it. Besides, they're still studying. So her boyfriend searched on the internet on how to abort their baby. And he found out the medicine that he needed to take Maria to abort her baby. Without knowing of Maria, her boyfriend put some medicine to Maria's drinks that result of dying of their baby, and it died. With that, we can see of the purpose of the perpetrator. He wanted and he successed to kill their innocent child just because of their irresponsibility. And for that, he facing the punishment under Article 256. Let's now proceed on the example of Article 257. This article is almost the same with Article 256. So Maria and her husband is very happy when they found out that Maria is pregnant. The long wait is over. One day, Maria went grocery to buy some foods. Her husband drunk when she got home. He told to Maria that this is for his celebration for Maria's pregnancy. Maria is anxious because whenever her husband drunk, he have an anger issue that result to use a violence to her. And it's happened. He slapped her and Maria felt watery on his feet and they noticed that it is a blood. They go to the hospital but it's too late. Maria lost their baby. In this example, we will notice that the abortion is committed unintentionally.
Good day everyone. Let's now move on to the Article 258, but before that, let me introduce myself first. I'm Raven Edricham Sagpao of BESI 2-6. Article 258, Abortion practiced by woman herself or by her parents. The punishment for this article is prison correctional. The liable is the woman who shall practice abortion upon herself or shall consent that any other person should do so. Let's begin by knowing its elements. So the first element is that there is a pregnant woman who has suffered an abortion. Second, that the abortion is intended. Third, that the abortion is caused by A, the pregnant woman herself, B, any other person with her consent, or C, any of her parents with their consent for the purpose of concealing her dishonor. After giving the elements of this article, let me give you an example. Maria is pregnant as a result of rape that happened to her and she is very angry. Because of that, when the child is still in her womb, she make away or move and aborted the baby. With this, if her parents do the same thing, cause an abortion, and give consent to their child, they will be also held liable for this article. Aside from Article 258, abortion practiced by the woman herself or by her parents, there are also some kind of abortion practiced by other people that are considered illegal by the law. It is the Article 259, abortion practiced by a physician or midwife and dispensing of abortive. All people mentioned in the title are all criminally liable for this article. Physician and midwives who uses their scientific knowledge or skills to cause, help, or assist a pregnant woman to commit abortion. Also, those pharmacies who, without proper prescription from a physician, shall give, sell, or administer any abortive. The punishment or penalty for this article is arresto mayor for the pharmacist, and for the physician and midwife, their penalty shall be imposed in maximum periods. What is the reason behind the implementation of maximum periods for physician and midwife? The answer is that their duty and their responsibility is for the improvement and preservation of life. Their scientific knowledge and skills should not be used in destruction of life, and abortion is one of the examples of it. How about for the pharmacies who sell an abortive? Should the pharmacist know the reason behind the purchase of drugs considered as abortive? No. This law does not state that the pharmacist should know the purpose of it, nor if the abortive has been used or not. But what the law says is the selling of an abortive without a prescription from a doctor. In some instances that the pharmacist has the knowledge for the purpose and use of the abortive, then he or she can now be considered as an accomplice in the crime of abortion. There are also some information about this article, or what we call the elements that we should always remember. So the first element is that there is a pregnant woman who suffered from abortion. Second, that the abortion is intended. Third, that the offender, who must be a physician or midwife, causes or assists in causing the abortion. And fourth, that said physician or midwife takes advantage of his or her scientific knowledge or skills. As to the pharmacist, the elements are: first, that the offender is a pharmacist. Second, that there is no proper prescription from a physician. Third, that the offender dispenses any abortive. To further understand this article, let me give you an example. A pregnant woman was rushed into the hospital. Upon checking, the physician decided to abort the baby. The physician said that she did the abortion in order to save the mother's life, because if she will not do it, the mother's life will be put at risk or might die. The question, is the abortion made legal or illegal? In this scenario, the abortion was legal. It is called therapeutic abortion. It is recognized by the Philippines jurisprudence and is allowed in the country as means of saving the life of a pregnant woman. Next scenario, a pregnant woman came to lying in hospital. She consulted a midwife and asked the midwife if she can help her abort the baby. The pregnant woman promised the midwife a big amount of money. Therefore, the midwife gladly accepted the offer. In this case, the midwife is liable for Article 259 as she uses her scientific knowledge and skills in assisting in an abortion.
Good day guys, for today's topic, I'm your reporter Papa Miko, and I'm gonna report the Article 260 and 261. Before we proceed in Article 260 and 261, first let's define what is a duel. According to Merriam-Webster, a duel is a combat between two persons, specifically a combat with weapons. It is sometimes caused by a conflict and misunderstanding. And according to the law, duel is defined as a formal or regular combat previously concluded between two parties in the presence of two or more seconds of lawful age on each side, who make the selection of arms and fix all their other conditions of a fight. Now that we have defined the word duel, let's proceed to Article 260, which is the responsibility of participants in a duel. This article states that if a person kills his adversary or enemy in a duel, he shall be punished upon reclusion temporal, or same with the penalty imposed in homicide. But if he shall inflict upon the latter physical injuries, only then he shall suffer the penalty provided therein, like force, like physical injuries. The penalty imposed was arresto minor according to Article 266. In instances when there are no death or physical injury caused to other party, then they are only punished with the arresto mayor, and the latter or second shall be considered as accomplice. To make it simple, those persons who are liable under this article are those persons who killed, inflicted physical injuries upon his adversary, or both combatants in other cases, as principals and the second as accomplice. How about the acts punished in a duel? Acts like killing one's adversary, inflicting physical injuries, and making a combat even without physical injury inflicted. To further understand this, let me give you an example. Pedro Nuan was a long-term business rival. Due to an investor, these two decided to talk. But during their meeting, the two had a misunderstanding that led to a duel between their bodyguards. Because of this duel, a formal combat happens, where the two parties use different weapons to attack each other. Upon the duel, Pedro was badly injured. Do you think that they are responsible under this article? The answer is yes, as both parties are involved and caused a duel which led to a formal combat, and Pedro has been injured due to the duel. You will read this article. You can see that the scenario's elements was present to be able to charge this article. Now for the second article, under duel is Article 261, or the challenging to a duel. Any person who shall challenge another or incite another to give or accept a challenge to a duel, or shall scoff at or decry another publicly for having refused to accept a challenge to fight a duel, or those who will be identified as challenger or instigator, are all liable under this article. For the penalty of prison mayor and its medium period shall be imposed upon, but there are also other circumstances that does not fall under this article, or cannot be considered as challenging to a duel. A mere challenge to fight without contemplating a duel or proper combat is not considered as a challenge. For example, a person who has challenged another person because of ill feeling, anger, or hatred, but when the other party calmed down in front of him, he refuses to fight back, and his action can only be considered as light threats, but not under this article. Another example, when Juan challenged Pedro to a duel, but Pedro refused to challenge, but when Pedro refuses, Juan keeps on pestering, provoking, and mock him. Because of that, Pedro decided to accept the challenge. They decided to have a formal combat that afternoon. After Pedro accepted the challenge, do you think they are liable? Yes, because the challenge happened and it was not a mere threat only. Also, there is one who challenged Pedro, and the latter accepted the challenge.
Now, let's proceed to the Section 2 of Title 8 about physical injuries. Under the Section 2, we have Article 262, mutilation. Mutilation means the lopping or the clipping off of some part of the body. There are two kinds of mutilations. First, unintentional mutilation in order to deprive totally or partially a person on some of his essential organs for reproduction, such as penis and ovary. The second one is by intentionally making other mutilation, that is by lopping or clipping off any part of the body of the offended party, other than the essential organ for reproduction, to deprive him of that party of his body. The kind of mutilation is punishable under this act, and reclusion perpetua shall be imposed upon any person who do the act. But any person who intentionally mutilate other parts aside from the reproductive organs shall be punished of prison mayor in its medium and maximum period. There are also some elements to determine whether the act is under this article. The following are: first, that there be a castration, that is mutilation of organs necessary for generation, such as the penis or ovarium. The second, that the mutilation is caused purposely and deliberately, that is to deprive the offended party of some essential organ for reproduction. Aside from this, we should take note that the punishment for those offender who perform the act of mutilation in a kid under 12 years old is reclusion perpetua. May it be considered as other kind. To further elaborate this, let me give you an example. There is a man who was diagnosed of autism when he was 4 years old. His family decided to have him vasectomy, but her sister found it immoral, saying that they are liable under Article 262. Is the family really liable? The answer is no, as vasectomy is not a form of mutilation, as this process is not a permanent and can be reversible, unlike in mutilation punished under Article 262. Mutilation cannot be changed as it is removing a body part completely and permanently. And another example, when a wife thinks that her husband might cheat or already cheating from him, he decided to cut the male organ or the penis of his husband. Therefore, in this act, the wife is liable under this article, as cutting of the reproductive organ is one kind of mutilation, especially when the purpose or reason behind this unacceptable.
Next,
Let's talk about Article 263, serious physical injuries, and its nature and penalties. First, how is it committed? It is committed by wounding, by beating, by assaulting, and the last one is by administering injurious substance. According to this article, any person can be held liable if they commit at least one of those acts. I mentioned earlier, it may be committed through reckless imprudence or by simple negligence under Article 365 in relation to Article 263. When due to lack of precaution, the accused wounded the offended party. For example, a drunk driver who accidentally hit someone while driving a vehicle. Hopefully, the offended party survived. We can see that negligence of the driver produced harm to the victim. Another one, please take note that intention to kill must not be present in the commission of this offense, because if there is intent to kill, the crime would be either frustrated or attempted murder, parricide, or homicide. Let's proceed to the penalties provided in this article. Let me discuss them one by one. In first paragraph, it says that when injured person becomes insane, imbecile, impotent, or blind. The term impotent means inability to copulate or produce a child, or in Tagalog, the offended party becomes baog. Aside from being impotent, the victim becomes insane and blind, wherein the blindness requires loss of vision in both eyes. If all the consequences are present, the accused will suffer the penalty of prison mayor. But if the victim of serious physical injuries under this paragraph is under 12 years old, the penalty should be reclusion perpetua. Next, proceed to paragraph 2. When the injured person loses the use of speech or the power to hear or to smell, or loses an eye, a hand, a foot, an arm, or a leg, or loses the use of any such member, or becomes incapacitated for the work in which he was therefore habitually engaged, the accused must suffer the penalty of prison correctional in its medium and maximum period. And also under this paragraph, the loss of power to hear must be in both ears, while the loss of use of hand or incapacity to do work must be permanent, not just temporary. All the body parts mentioned a while ago are considered principal members. Okay, next to paragraph 3. When the person injured becomes deformed or loses any other member of his body or loses the use thereof, or becomes ill or incapacitated for the performance of the work in which he was habitually engaged for more than 90 days, the punishment will be prison correctional in its minimum and medium period. The injured parts must be any member of the body and should not be considered as the principal member of the body. For example, the loss of use of fingers. That kind of injury incapacitates the victim to do his task. Therefore, it is still under serious physical injuries. And also deformity is also mentioned in this part, which requires the following. First, physical ugliness. Second, permanent and definite abnormality. And third, must be conspicuous and visible, and take note that if the scar or wound is usually covered by clothes, it would not be conspicuous and visible. And also, deformity is not curable by natural means or by nature. Under this paragraph, the victim or offended party must be ill or incapacitated for more than 90 days. If lower than the prescribed days, it might fall under paragraph 4. Okay, proceed to paragraph 4. It says that when the injured person becomes ill or incapacitated for labor for more than 30 days but not more than 90 days, the punishment will be arresto mayor in its maximum period to prison correctional in its minimum period. The fourth paragraph does not refer to the labor in which the offended party is engaged at the time the serious physical injuries are inflicted. The incapacity is for any kind of labor or work. For example, the victim's leg was injured due to negligence of the accused. Because of that, the victim can't perform any task, even a simple one, due to the fact that he can't walk and move his legs. Also, the injury must require hospitalization for more than 30 days to distinguish it as serious physical injury. If the victim filed a complaint against the accused for serious physical injury, under paragraph 4, the victim must provide an evidence showing that he or she suffered for a period of more than 30 days, but not more than 90 days of being incapacitated for labor. If not, the offense will fall on slight physical injuries only. And under this article are the qualifying circumstances, which are the following. First, offense committed against persons enumerated in the crime of parricide. Second, with the attendance of circumstance which qualify the crime to murder. If these circumstances are present, the law provides higher penalties than prescribed penalties of serious physical injuries. However, the qualified penalties are not applicable to parents who inflict injuries to their child due to excessive chastisement.
Good day everyone, I am Jessica Ferreira of Bachelor of Science in Criminology 2-6, and for today's video I am going to discuss to you the Article 264 and Article 265. Article 264, administering injurious substances or beverages. The penalty under this article would be based upon the penalties provided in Article 263, since it says that the injuries inflicted is serious physical injuries. So, what are the elements? 1. That the offender inflicted upon another any serious physical injury. 2. That it was done by knowingly administering to him any injurious substances or beverages, or by taking advantage of his weakness of mind or credulity. 3. That he had no intent to kill. What are those injurious substances or beverages? From the word itself, injurious, meaning it can cause a serious injury to someone. So, these are those chemicals that have harmful effects to humans, which can cause death if medical assistance is not given immediately. So, how it is committed? It is committed by administering injurious substance, meaning to say putting the substance inside the body of the victim through injection, through the mouth, or by drinking the substance. The mere throwing of the chemicals or poison on the body is not administering an injurious substance. To further understand this article, let me give you an example. Juan, who was at the party, gave a glass of juice to Maria. Maria had no idea that her juice was mixed with a substance that will make her lose her sanity. After a few minutes, Maria passed out, and her body became paralyzed because of the drugs in her drink. It was a signal for Juan to commit his plan while Maria was unconscious and not in her normal state. Based on the example, the victim lost her sanity and was not able to resist Juan's motive. Juan, who is the accused, is liable under this article because he administered an injurious substance to the victim by giving her drink with drugs. Based on the element, he takes advantage of Maria's weakness of mind and credulity. Another point is that Juan has no plan of killing the victim, therefore he will be held liable under Article 264. Article 265. Less serious physical injuries. The penalties under this article is arresto mayor. The law says that any person who inflicts another physical injuries not described in the preceding articles but incapacitate the victim for labor for 10 days to 29 days shall be guilty of less physical serious injuries. So, here are the elements. 1. The offended party is incapacitated for labor for 10 days or more but more than 30 days or need medical attendance for the same period. Take note that if the incapacity is more than 30 days, it is a serious physical injury. 2. The physical injuries must not be those described in the preceding articles. Under this article, medical attendance or incapacity is required. The law provides two divisions. 1. The inability for work and 2. The necessity for medical attendance. If the medical attendance only lasts for 2 or 3 days, and the injured party is still incapacitated for labor for period of lower than 30 days, it is still considered less serious physical injuries. Same with this, if the offended party or the victim is not incapacitated for the performance of work in which he was habitually engaged, but the injury inflicted upon him or her needs to be treated for less than 30 days, it is still less serious physical injuries. There are also qualifying circumstances for less serious physical injuries. Here are the following. 1. A fine not exceeding 500 pesos in addition to arresto mayor shall be imposed for less serious physical injuries when A. There is manifest intent to insult or offend the injured person, or B. There are circumstances adding ignominy to the offense. The ignominy was mentioned here. It is defined as a circumstance pertaining to the moral order which add disgrace and obloquy to the material injury caused by the crime. Take note that the mere insult to the victim without injuries inflicted is not less serious physical injuries. There must be an injurious and shameful act toward the victim to qualify the offense. 2. A higher penalty, which is prison correctional in its minimum and medium period, is imposed when the victim is either A. The offender's parents, ascendants, guardians, curators, or teachers. B. Person of rank or person in authority, provided the crime is not direct assault. If the victim is one of those people enumerated under paragraph 3 of Article 265, the penalty will increase because it is very inhuman and for inflicting injuries toward your mother, father, grandparents, teachers, and also towards the person in authority. That's all. Thank you.
Article 266, the slight physical injuries and maltreatment. The penalties under this article depend upon the kinds of injuries inflicted. So, there are three kinds of slight physical injuries mentioned in this article. 1. Physical injuries which incapacitated the offended party from 1 to 9 days or required medical attendance during the same period. The offender under this circumstance shall suffer the penalty of arresto mayor for inflicting injuries which prohibit the victim to do his work for a period of 1 to 9 days, as well as the healing process of the injuries must be sustained for the same period. Number 2. Physical injuries which did not prevent the offended party from engaging in his habitual work or which did not require medical attendance. According to this paragraph, the penalty of arresto menor or a fine not exceeding 200 pesos and censure are imposed upon the offender. Example of this circumstance is contusion on the face or black eye produced by one fistic blow or punch. Black eye does not require medical assistance because it can be treated at home. Number 3. Ill treatment of another by deed without causing any injury. While in this circumstance, the penalty imposed upon the offender is arresto menor in its minimum period, a fine not exceeding 50 pesos. For example, slapping the face of the offended party without causing dishonor. Let me further discuss this article. Based on the enumerated circumstances, is it necessary for the offended party to present any evidence of actual injury? The answer is no. There is no need to present proof of hospitalization or incapacity for labor, as long as the injuries inflicted upon the victim are not the same as the injuries enumerated under these articles 263 and 265. The accused will be punished under this article. How about the scenario like this? In the complaint, the offended party says that the accused conspired to murder her, but the offended party only got contusion resulting from the fist blows by the accused on her. Does the accused guilty of attempted murder? The answer is no. The accused is only liable for slight physical injuries because the offended party lacks evidence to prove that the conspiracy is present. And also based on the injuries inflicted upon her, we can say that the injury is not that critical or consider crime as attempted murder. Included also in this article is the crime of rape. Under this chapter 3 of Title 8 from Article 266A to 266B, rape is defined and discussed. Rape is classified as traditional rape, which is also defined in Article 335, and sexual assault under Republic Act 8353 or the Anti-Rape Law of 1997. So how is it committed? Number 1. It is committed by a man who shall have carnal knowledge of a woman under any of the following circumstances. A. Through force, threat, or intimidation. B. When the offended party is deprived of reason or otherwise unconscious. C. By means of fraudulent machinations or grave abuse of authority. D. When the offended party is under 12 years of age or is demented, even though none of these circumstances mentioned above be present. Under this paragraph, the penalty of reclusion perpetua shall be imposed upon the offender. Higher penalty will be imposed if the rape is committed with the use of deadly weapon or by 2 or more persons. When the victim became insane after committing the crime and when the rape is attempted and homicide is also committed. Number 2, by any person who under any of the circumstances mentioned in paragraph 1 hereof shall commit an act of sexual assault by inserting his penis into another person's mouth or anal orifice of another person. Under this paragraph, the offender shall be punished by prison mayor. When rape is committed with the presence of a deadly weapon or by 2 or more persons, the penalty will be prison mayor or reclusion temporal. When the victim became insane, reclusion temporal shall be applied. These are the qualifying circumstances which aggravates the penalty imposed upon the accused. Next is when the rape is attempted. However, a crime of homicide is committed when the penalty shall be reclusion temporal or reclusion perpetua. And the last one is when by reason or on occasion of the rape, homicide is committed, the penalty shall be reclusion perpetua. 1. When the victim is minor and the offender is a parent, ascendant, step-parent, guardian, relative, by consanguinity or affinity within the third civil degree, or the common law spouse of the parent of the victim. Number 2. When the victim is under the custody of the police or military authorities or any law enforcement or penal institution. 3. When the rape is committed in full view of spouse, parent, or any of the children or other relatives within the third civil degree of consanguinity. Number 4. When the victim is religious, engaged in legitimate religious vocation or calling, and is personally known to be such by the offender before or at the time of the commission of crime. Number 5. When the victim is child below 7 years old. Number 6. When the offender knows that he is afflicted with HIV or AIDS or any other sexually transmissible disease and the virus or disease is transmitted to the victim. Number 7. Committed by any member of the AFP or paramilitary units thereof of the PNP or any law enforcement agency or penalty institution when the offender took advantage of his position to facilitate the commission of the crime. Number 8. When by reason or on the occasion of the rape, the victim has suffered permanent physical mutilation or disability. Number 9. When the offender knew the pregnancy of the offended party at the time of the commission of the crime. Number 10. When the offender knew the mental disability, emotional disorder, and or physical disability of the offended party at the time of the commission of the crime. Who can commit rape? According to the Republic Act No. 8353, this kind of crime can now be committed by a male or a female. Nowadays, anyone can commit a crime of rape. Same with the victim. It's either boy or girl can be a victim of rape. Is there any chance to acquit or extinguish the criminal liability of the offender of rape? The answer is yes. In cases wherein the offended party decided to marry the offender, the criminal case will be dissolved. Take note, it is only applicable to the offender to whom the victim is going to marry. Another circumstance that acquits criminal liability is when the offender is the legal husband of the victim. If the wife, which is the victim, forgives her husband, the offense will be extinguished. Take note that it will take effect only if their marriage is still legal. So what are the evidences accepted in the prosecution of rape? According to the Article 266D, the following evidences are accepted. A. Any physical overt act manifesting resistance against the act of rape in any degree from the offended party or where the offended party is situated as the render him or her incapable of giving consent.